This training module will explain what a Part 2 order request is, what should the proponent do and not do to avoid a Part 2 order request, the proponent responsibilities, the public's responsibilities, and the review process. Municipal Class Environmental Assessment provides the framework for environmental assessment planning of municipal infrastructure projects to fulfill the requirements of the Environmental Assessment Act. A common feature of class environmental assessment documents is a provision which enables any individual, group, or agency that has significant environmental concerns with a project to write to the Minister of the Environment or delegate requesting that the project undergo an individual environmental assessment, i.e., bump up the status of the project under the Environmental Assessment Act. Formerly known as a bump up, a Part 2 order is an order issued by the Minister that makes a class environmental assessment project an undertaking that is subject to Part 2 of the Environmental Assessment Act and requires the completion of an individual environmental assessment. There are streamlined self-assessment processes, Class EAs, that can be used for groups or classes of projects that are carried out routinely, have known impacts, and that are predictable and manageable, therefore do not warrant an individual environmental assessment. The approved class environmental assessment document establishes a streamlined planning process for proponents to follow in order to fulfill the requirements of the Environmental Assessment Act for approval of a project within the class of undertakings. Individual environmental assessments, Part 2 of the Environmental Assessment Act, are those projects for which a terms of reference and an individual environmental assessment are carried out and submitted to the Minister of the Environment for review and approval. Who can submit a Part 2 order request? Any individual, group, or agency that has significant environmental concerns with a municipal project subject to a class environmental assessment can make a Part 2 order request. What a Part 2 order request should be is a way in which the proponent, an interested person, Aboriginal community, or government agency with a significant concern about the potential environmental effects of a proposed class environmental project can request that a higher order of environmental assessment be undertaken so that the concerns can be addressed. Submissions for Part 2 order requests are to be made in writing to the Minister or delegate with a copy to the proponent, made after all of the planning is complete, after the notice of completion is issued, and within the specified review period outlined in the notice, so that all of the potential environmental effects and impact management measures are understood, and are to focus on potential environmental effects of the project, the class environmental assessment process, and not on decisions made outside the class environmental assessment process. A Part 2 order request should address the following issues as it relates to a proposed municipal project: potential environmental impacts of the project, the adequacy of the class environmental assessment planning process, public consultation program, and opportunities for public involvement, assessment and consideration of other alternatives to the proposed project, and why an individual EA should be required. If the proponent is able to address the concerns of the requester, the request should be withdrawn promptly by the requester. Part 2 order requests should not be a mechanism to stop, delay, or frustrate the planning and implementation of a class environmental assessment project, to revisit issues with which the requester does not agree and that have already been decided through another planning process such as official plans, growth plans, and infrastructure plans, to be used simply because the project is not desired in a community, to deal with broad policy issues that do not have government policy direction and are not directly related to the proposed class environmental assessment project, such as adequacy of funding for transit or meeting the Kyoto Accord. Part 2 order requests are not a means to resolve issues that can be dealt with through other methods such as permits, licenses, or planning processes such as local municipal bylaws and building permits. In order to avoid Part 2 order requests, proponents should participate meaningfully in consultation processes, explore options to address issues and identify workable solutions, provide clear and traceable documentation, and provide opportunities to arrive at solutions before issuing the notice of completion and documentation for public review. Interested parties also have responsibilities to participate meaningfully in consultation processes. When interested parties raise concerns in a timely manner, the proponent may be able to explore options to address issues and identify workable solutions. Interested parties who have concerns about a project should be clear whether the issue relates to the effects of the project activity or the class environmental assessment process. Interested parties should not be requesting proponents to revisit concerns with previous planning decisions that have been made through another planning process. Proponents are only responsible for responding to concerns associated with the class environmental assessment planning process and the potential environmental effects of a project activity. For example, if a municipal land use planning decision has been made to allow for residential development in the northern part of the municipality and a class environmental assessment is being undertaken for sewer servicing, the class environmental assessment process will only address the environmental effects assessment of the servicing component, not whether the approved land development should occur. Project evaluators will evaluate each request and develop the most appropriate recommendation based on the information available, including technical review, government and ministry mandate, and current legislative requirements. Project evaluators will focus their attention on the specific issue or issues raised in the Part 2 order request. Depending on the issue being raised, they may require coordination with other Ministry of the Environment offices, technical support staff, and other agencies and ministries. They will review the project documentation to determine if the Class EA requirements under the Municipal Environmental Assessment Class EA have been met. Once the ministry receives the request, the project evaluator will advise the proponent of the receipt of the request. Where appropriate, proponents are encouraged to carry out further discussions with the requesters to attempt to resolve any outstanding concerns and inform the ministry about the status of these discussions. The proponent has the option of making a submission addressing the issues to the branch. The ministry may consult with other government agencies or other interested parties, including the requester, before a decision is made. The project evaluator will review the information and prepare a recommendation for the minister or delegate's consideration. The basis for the Part 2 order is defined under subsection 16(4) of the Environmental Assessment Act. The minister shall consider the following matters when making an order under this section: the purpose of the act, the factors suggesting that the proposed undertaking differs from other undertakings in the class to which the environmental assessment applies, the significance of the factors and of the differences, the concerns raised by the requesters, the mediator's report, if any, following a referral under subsection 6, such other matters as may be prescribed, such other matters as the minister considers appropriate. Other matters the minister may consider appropriate could include, but are not limited to, the extent and nature of public concern, potential for significant adverse environmental effects, consideration of alternatives by the proponent, considerations of urgency, participation of the requester in the planning process, the nature of the request, implications for matters of provincial interest, and the degree to which public consultation and dispute resolution have taken place. MOE will reply to the proponent within 45 days of receiving a Part 2 order request. Once MOE has advised a proponent of the receipt of a request, the proponent will need to respond to the issues raised with a written record of its responses to the branch within the specified time, usually 2 weeks or sooner. In order to ensure timely reviews, timelines for agency reviews will be implemented. Agencies will be asked to provide comments to the branch by a specified date, typically within 2 weeks. Recommendations on a request typically range from 30 to 66 days, depending on the issues raised. Once the minister or delegate receives the recommendation about the Part 2 order request from the MOE, the minister or delegate has 21 calendar days to make a decision about the request. Under the Environmental Assessment Act, the minister or delegate has a number of options when making a decision on a Part 2 order request. There is the option to deny the request with conditions, refer to mediation prior to making a decision, and to grant the request and require the proponent to undergo an individual environmental assessment. Can master plans be subject to Part 2 order requests? No. Only the projects identified within a master plan are subject to Part 2 orders. When can I submit a Part 2 order request? A Part 2 order request may be submitted in writing to the Minister of the Environment within the minimum 30-day public review period after the proponent has issued a notice of completion. A request should be made only when there are outstanding significant environmental issues that cannot be resolved through the Class Environmental Assessment process, through discussions with the proponent, or mediation. A Part 2 order request is considered to be premature when it is received during the early planning stages of the Class Environmental Assessment process, prior to the issuance of the Notice of Completion. If the request is premature, the requester will be advised that it should bring its issues to the attention of the proponent. What information should I include in a Part 2 order request? Information in a Part 2 order request should include, but is not limited to, name and address of the requester, name of the project and proponent, details about the undertaking, a clear indication that a request for a Part 2 order is being made, the specific reasons for which the request is being made, rationale as to why a higher level of assessment would address the concerns raised in the request with the proponent, information about any efforts to date to discuss and resolve the concerns with the proponent, and other matters that may be considered relevant. Under the Freedom of Information and Protection of Privacy Act and the Environmental Assessment Act, unless otherwise stated in the submission, any personal information such as name, address, telephone number, and property location included in a submission will become part of the public record files for this matter and will be released, if requested, to any person. What happens after the minister has made a decision? Once a Part 2 order request has been denied, the proponent may proceed with the implementation of the project subject to any conditions imposed. Where a Part 2 order has been granted, the proponent may begin to prepare terms of reference for an environmental assessment subject to any conditions imposed if the proponent wishes to receive approval for the project under the Environmental Assessment Act. The minister's decision regarding a Part 2 order request is final and not subject to appeal.